Tennessee is one of 26 states blocking some kind of gender-affirming care for children. The ruling in this case could have implications across the country. An emotional day outside the Supreme Court, a line of fences separating protesters on both sides of the debate.
This case is all about protecting children. It's about protecting children from the kind of evil that everybody in the world has recognized as evil.
The plaintiffs in U.S. v. Scarametti argue Tennessee's law banning certain gender-affirming care for minors violates the Equal Protection Clause of the 14th Amendment because of sex-based discrimination.
It's not very comfortable being trapped in, because it just doesn't feel like you.
In contrast, Tennessee lawmakers who passed the law argue that it's necessary to protect children from potential long-term harm of irreversible medical treatments.
In Tennessee, we think this is a risky procedure.
Wednesday's oral arguments mark the first time the High Court has directly considered a state law regarding transgender people.
This case is about access to medications that have been safely prescribed for decades to treat many conditions, including gender dysphoria.
However, those in favor of Tennessee's law argue that caution is needed in light of documented cases of regret among some youth who have transitioned, raising questions about medical risks of those treatments for minors.
These interventions carry often irreversible and life-altering consequences, and the systematic reviews conducted by European health authorities have found no established benefits.
The justices seemed divided on these points, with the liberal justices pressing Tennessee's attorney on the potential harm of such laws.
One of the articulated purposes of this law is essentially to encourage gender conformity and to discourage anything other than gender conformity. And I'm wondering how you think that plays into the analysis.
Conservative justices framed the issue differently.
At a big picture level, I think the argument on the other side, putting aside some of the details, is why not trust parents rather than the state, particularly in a situation, as General Prelager said, where there's not the kind of direct harm to third parties that you might see in other contexts like sports.
Yes, Your Honor. So, as my friends recognize, the parental rights question is not before this court.
Conservative Justice Clarence Thomas argued the law wasn't an outright ban, but rather focused on the age of the patients seeking treatment.
So why isn't this simply a case of age classification when it comes to these treatments, as opposed to a ban, as you suggested in your opening statement?
Chief Justice Roberts questioned whether the court is the best body to make decisions on evolving medical issues. The ruling will, of course, be watched closely by both sides and is expected by June. At the Supreme Court, I'm Tara Mergener, CBN News.